And now we're going to go back to House Bill 2571, which we recessed, reopen the public hearing, and I'm going to go ahead and call up Ryan Lufkin, Michael Savaggio, and Kevin Campbell, and Kimberly McCullough. Do four. All right, gentlemen, as you know, we are somewhat short on time, so if you can keep your remarks focused. This bill is not ready to move forward, so we're not going to work it today, but I do want to get your testimony on the record.
Mr. Chair and members of the committee, for the record, my name is Kevin Campbell. I'm the Executive Director of the Oregon Association Chiefs of Police, and I'm here today on behalf of the Chiefs and the Sheriff's Associations both in support of House Bill 2571A. There is a small technical amendment. It's, I believe, the -8 amendment, so we do support the addition or the committee's consideration of adding that amendment. It's a one-word oversight, and there's no real additional substantive changes that we believe are necessary to the bill. This was one that's been negotiated significantly among a wide range of parties, and we believe this would allow agencies to move forward to implement a body-worn camera system permissively and in a way that would benefit the public. And so we support the bill. I did submit my written testimony, and I don't want to say anything more because of the shortness of time, but we do support the bill and appreciate the committee's consideration. Thank you.
I appreciate that, and I should have said this earlier. If you have written testimony, please don't read it. Of course, we'll have it for our review. Michael, you going next?
Sure. Mr. Chair, members of the committee, for the record, Michael Salvaggio, representing the Oregon Coalition of Police and Sheriffs. I did submit testimony to OLIS. I would like to just put a couple of brief things on the record in addition to our support of 2571 as it currently stands and with the amendments. The version currently provides for local governments to establish their own policies in addition to the policy floor that the bill supports. So I just want to make it clear that we support what Mayor Hales and Representative Williamson described, which was that local governments and local law enforcement agencies will be describing their own policies in addition to what we see in this bill. We've had a broad discussion about privacy and civil records, and we originally envisioned stronger protections on this, but we feel that the current bill represents a fair and appropriate compromise. We expect that the current rules around public records will prevent footage from being subject to records requests before the completion of any associated legal proceedings. Although the footage, of course, may be used as part of those proceedings in an investigatory or evidentiary capacity. So we're pleased to support the bill, and thank you for your time.
Thank you. Ryan?
Good morning, Chair Przansky, members of the committee. My name is Ryan Lufkin. I'm a Deputy District Attorney with Multnomah County and a member of the Law Enforcement Responsible Technologies Group that helped to work on this bill in collaboration with some of the partners here today. And I want to state that we're highly supportive of this bill. It was strongly negotiated. It has a wide-ranging impact on how law enforcement will do its job and then subsequently how the prosecution of criminal cases will occur. So I'd just like to highlight, as I did in the House, that this bill represents the beginning of one of the most fundamental changes to how police will collect evidence since the invention of the police report, because we're envisioning that this video will be available in all criminal prosecutions for which there are police officers involved, which is basically every single criminal prosecution. And that has wide-ranging impacts on how prosecution occurs. And this bill does a good job at getting at some of the issues that devolve from that in additional evidence, because our system is not really set up right now to handle hours and hours of video footage coming into every single criminal case. So some of the features that I want to highlight for your attention in this bill are, it does set a requirement for law enforcement to turn on their video camera at a specific point in time, which is when the officer develops reasonable suspicion that a crime or traffic infraction has begun and the officer begins to make contact with the individual involved, and does not allow for the termination of that video to occur until after the officer has ceased his contact. That is the general standard that applies, and then the bill permits local agencies to exempt from that requirement when there are concerns for privacy, when there are concerns for safety, when there are concerns for exigency, because as the folks that were around the table negotiating this language, I think came to realize the permutations of different scenarios that can occur inside people's homes, inside hospitals, inside schools, with juveniles. Each community is going to grapple with those issues with respect to recording differently. The other features of the bill that are important to us, it does create a minimum retention period of 180 days and a maximum retention period of 30 months. And that was intended to get at both the minimum required time to file a lawsuit and the maximum required time to file a lawsuit. The 8th amendment that is not ready to be moved today, but which we support, clarifies, I think, what was just an unintended drafting issue, which is that we're not intending to destroy evidence that exists for criminal investigations. This was essentially a cleaning mechanism for video that has no purpose any longer. And that time range when that cleaning was supposed to happen is at 30 months, but it was not intended to force officers to go destroy physical evidence of crimes they're currently investigating. And so that's what the Dash 8 was intended to do. One of the features that's important to us as prosecutors is that there's a 60-day time limitation to bring a defendant who is in custody to trial. That time limitation is already extremely difficult to meet on your average case, and what we envision happening in cases where you have, sometimes 20 or 40 hours of video footage is that time limitation is going to be really just impossible to meet, particularly with the amount of video editing that we're envisioning that needs to happen, because not all video is just going to be played before a jury. Some parts are going to be admissible, some parts are inadmissible. This statute provides the court the ability to weigh that issue and appropriately grant good cause exceptions to that 60-day window. And that was extremely important to us to get this bill in a place where we think it would be workable. And then finally, on the public records point, we are very happy with the language that was crafted. It's a difficult issue to grapple with. The concerns over privacy are fairly extreme when you have most officer contacts not resulting in an arrest. And we've already seen examples in other jurisdictions where the kind of blanket request, give me all your video, has simply drowned law enforcement agencies from being able to actually comply with legitimate public records inquiries. So the language that we've crafted was intended to get at that issue, get at the actual applications, make sure that they are constricted to real specific events so that we can respond to them appropriately and release public records when appropriate. So it's a difficult issue, but I think that this bill has really reached the right compromise on all these issues, and we're very pleased to be able to support it.
All right, thank you. Kimberly?
Chair Przanski, members of the committee, my name is Kimberly McCullough. I'm here on behalf of the ACLU of Oregon in support of House Bill 2571A. I'd just like to point out that there were initially several different competing bills that were introduced, and one of those was a bill that we were very strongly supporting, and there were a number of provisions in that bill that ended up getting imported into this bill, which is why we support it, because it was really a compromise between all the different competing concerns. And this issue in particular, as was already pointed out, is fairly complex because there really are competing values of wanting to increase transparency, but at the same time protect privacy. In particular, of people who have encounters with law enforcement, where if those videos just sort of ended up on YouTube en masse, the repercussions for individuals could be fairly serious. Particularly when the court of public opinion doesn't always give people that innocent until proven guilty slant that our criminal justice system does. I just want to highlight a few things that we really like about this bill, in particular the fact that it prohibits the use of facial recognition technology, so that we can come back and have a conversation about that if that is something that law enforcement wants to use in the future. Also, the fact that it requires cameras to record continuously and that they can't be turned off once an officer is engaging with someone where there's reasonable suspicion or probable cause to suspect that a crime has been committed. The public records piece was really complicated here, and I just want to point out that some earlier versions had a few things in there that are not in this, but one of those is there was the allowance of disclosure if everyone in a video consented, and then also allowance of disclosure if there was a use of force or a misconduct investigation. It is our hope that the way that the public records piece is drafted right now would allow for those types of footage to actually get disclosed, because we believe those types of footage, it really is in the public interest to get that out. Of course, obviously, after there's investigation, trial, things like that. But that's something we're really going to have to see as courts interpret this public records piece. And so if this bill hasn't struck the right balance, this may need to be an ongoing conversation. But we think that we have done the very best that we can at this point.
I appreciate the brevity that we have here. Any questions,
Just
Senator Thatcher?
One that's been kind of bothering me, and I'm not real clear on it, is if I, for instance, had an interaction with the police, not me as a legislator, but a person has an interaction with a police officer, and those are not always, friendly encounters, and they're stressful, and you're going through this, and afterwards you're thinking, wow, did that just happen? I mean, did that really just happen? Can I look at the tape? Would I be able to access that?
Right, and I think that was what I was getting at there, is that I feel like those types of things, it really is in the public interest for a person to be able to view their own video if they're the only one in the video and they're consenting to it. But that is something that's going to have to be worked out by the courts and the DAs and when this is actually interpreted. So that's not articulated, but I don't, that's a complicated policy issue as well. You may want to make some comments about that as well.
Mr. Chair and Senator Thatcher, it is already the practice of law enforcement agencies when there's a case, for instance, where you are in an encounter and you either file a complaint or want to look at the video, they want you to see it. Mm-hmm. It's beneficial to them. It's beneficial to you. And a lot of times after reviewing it, sometimes there's a complaint made, and then you look at it and you feel like, oh, okay, I understand now. Or it could be a legitimate concern that you've raised. And so it's in the best interest of an agency to actually allow you to see that. I don't think that this bill is designed to prevent that. Mm-hmm. If you said, I think we're more concerned about the release of a video where you're party to it, you may not have an interest in seeing your encounter on some media site. So that's really the concern we were trying to get at. But I think agencies have it in their interest to want you to be able to view footage when there's an issue or a concern.
Okay.
All right. Senator Gelser.
Thank you, Mr. Chair. Can you describe what the definition is of approximate date and time? It's a pretty vague term.
Senator Gelser, Chair Przanski, the goal behind that language was to avoid the blanket requests of give me all your video for officer whoever, or give me all your video for the last year. So the idea was, let's say that if you're going to make a request, that request should be specific to as much information as you know about the event, so that we can deny the request if it's something super overbroad like I just described. And again, these public records issues go not just to the agency, but if appealed to the district attorney or the attorney general and then to court. So it's a matter of allowing the parties to hone in on what the request is based on the approximate date, time, and location of the event, some pieces of information that allow us to get at what you're truly after in a legitimate sense and not overexpand the release.
May I follow up? So in some cases, let's say there's a person a mentally ill person that's had an encounter that they have described to someone, and they cannot pinpoint the exact time or even the exact day. Mm-hmm. They know that it was the evening time, maybe sometime in the third week of August. Would that count as a approximate if they could say in this location, the third week of August, between 4 and 7 p.m.?
Senator Gelser, yes. The answer is yes. The goal behind this language was not to restrict a person from identifying the piece of video that they want. The goal of this language was to prohibit blanket requests for all video. So the idea is not to prohibit the person who has a challenging time remembering what what specific day the event occurred. The goal was, let's find the piece of video that you're asking us for and not release weeks and weeks of video that you're not asking us for. So I think the answer to your question is yes.
And I think there'd also be a cross check on that based on this individual having a name that's going to be probably in a police report. They'd be able to access that much easier. Again, this is really for that broad net.
And one last follow-up with that broad net. In talking with some of the newspaper publishers, if they were doing some sort of an investigative report, perhaps around a specific officer and the types of interactions they had with women or the types of interactions they had with people who were mentally ill, could that request, if they described what that investigation was about in the public interest, be for this officer over the course of a month when police reports have identified they were encountering a mentally ill person or a person of color or a woman?
Senator Gelser, again, the answer is yes. I think that request would get handled. It's not going to be prohibited by this language. The language is intended to narrow down what the request actually is. And I think on a case-by-case basis, depending on what the submission actually is, would get either approved or denied by the agency, go through the DA's office and through the courts to attempt to get at what the meat of the issue is and then weigh it whether or not it meets the public interest test. Yeah. So I think that's the goal of this language, but I wouldn't want to get pinned down on exactly what that is, because it could be the request is, well, we think Officer Jones is a bad guy, so give us everything he's ever done. No, right? And that would probably be denied.
Yeah, there's enough checks and balances in this process. If there's those allegations, and if the department says no, then there's a check with the district attorney as to, because it's a public records request, and if they say no, they can still go to court. And then if they have, let's say, affidavits from individuals, the court's going to take all that and weigh it. So to me, there's going to be those checks and balances to ensure, again, it's just not, we just want to go fishing.
Right. Thank you.
All right. Thank you all very much. I'm going to bring up our next panel.